The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your relatively bi-weekly podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined this week by Evan Bernick of IJ's Center for Judicial Engagement, as well as IJ attorney Ricard Poach Kanawala. This week on the show, a suspicious motorist, a renaissance against Chevron-style judicial abdication, prairie dogs, and illegal tattooing. Ricard, kick us off.
So this case, De La Rosa versus Trooper White, is an Eighth Circuit Court of Appeal case on qualified immunity. The defendant police officer stops the plaintiff driver for following another vehicle too closely. He questions the driver, receives answers to his questions, provides a warning, and says that the driver's free to go, all within 15 minutes. He then asks to search the driver's pickup truck. The driver refuses, and the police officer detains him for 50 minutes till a drug dog arrives. The dog alerts after sniffing the truck, and they find 3 guns and a small amount of marijuana. Now, the state charges for the concealed guns are dismissed because the search is found to be unconstitutional and an unreasonable search. The driver then sues the police officer under Section 1983 for violating his constitutional rights with the detention and search, and the officer claims qualified immunity and brings a motion for summary judgment. So the question really is on the officer's summary judgment motion, whether the police officer violated the plaintiff's clearly established constitutional rights in finding reasonable suspicion to detain the driver until the drug dog arrived. The district court rules for the plaintiff and says yes to that question, and the Eighth Circuit reverses and says no. So I'd make 2 points about this case. First off, from a litigation perspective, it seems that the plaintiff really should be allowed to get to at least a discovery stage in cases like this.
Summary judgment's a really initial stage of litigation before any evidence gathering is really taking place, in other words.
Exactly. It's on the pleadings, and it's showing that there's no material issue of fact, no issue of material fact. So before the plaintiff should at least be able to get to a stage of being able to discover the defendant, collect evidence, and then try and meet the test that the Supreme Court's laid out of showing that the defendant officer violated clearly established law, the plaintiff's constitutional rights. That's the first point. The second is that this case itself raises some troubling issues about the officer's reasons or purported reasons for that detention and search. The officer claimed that the plaintiff was very relaxed when being questioned, which is the exact opposite, in fact, of the undue nervousness that the Eighth Circuit has previously held to be reasonable, to grounds for
to be
reasonable
suspicious.
Sure. So it seems like we're now in the strange position where you can't be unduly nervous, or you'll alert the officer's suspicion and be detained, and you can't be very relaxed, or you'll be in the same situation. So it seems like there's a lot of subjective analysis going on here, or there's something else going on, and again, that's why we need the plaintiff to get to discovery to be able to collect that evidence.
And it's pretty evident what's going on in the opinion itself in terms of the premises that the court's working with and how it applies them in analyzing this fact pattern. The Eighth Circuit is taking what it understands to be dictation from the Supreme Court to the effect that there's basically nothing that an officer can do, short of being plainly incompetent or deliberately and maliciously harming somebody, that will prevent him from being given the benefit of qualified immunity if he's sued as a consequence of how he conducts the search of a car. I mean, we've beaten up on qualified immunity a lot over the course of Short Circuit, but this is a particularly stark example of a court just basically saying that if there's not an identical fact pattern, if we haven't confronted this particular case before and held what the officer did to be unconstitutional, you don't have a remedy for a violation of your constitutional rights. And in fairness to the Eighth Circuit, if one can be fair to the Eighth Circuit in this case, that's pretty much what the Supreme Court has said in a variety of contexts over the course of the last couple of decades, and it's getting worse rather than better.
I agree with that. I think there's a question about the policy of having such a high bar on qualified immunity cases, or to overcome qualified immunity, particularly at the pleading stage, as I was saying earlier. And this case is an example of that. But I think the Eighth Circuit doesn't even hold the officer's story fully to account. He mentions that the plaintiff driver had a tire in the back of the pickup truck in the bed.
Which is interesting.
Right. But he didn't. So that was suspicious, the officer claims. But he didn't actually ask the driver about why he had the tire in the bed instead of stowed away. If that really was a grounds of suspicion, he could have asked.
Right. And again, the fact that it was the driver's being unusually relaxed rather than agitated or nervous that set the officer off. I mean, it's a perennial struggle with these cases to distinguish officers' hunches from particularized objective evidence that would give rise to a reasonable suspicion. That's always difficult. Nonetheless, this is a particularly perplexing case from the perspective of somebody who would like to place any limits on officers' abilities to detain people and bring drug dogs just on the basis of a pure hunch that somebody's up to no good.
One other quick point. The officer also mentions that the driver wasn't honest about a 7-year-old dropped destruction of property charge. I think there's got to be a clear distinction. I mean, there is in the law, but it doesn't seem like it necessarily gets through to law enforcement in cases like this, that there's a difference between a charge and a conviction, and merely not saying that, yeah, I had a 7-year-old unrelated charge brought against me that was then dropped is somehow grounds for detention at a roadside stop.
You mean that when the officer asked if he had a criminal history, he said no, correctly, because he only had one dropped charge in his background, but the officer seemed to think that that was, in fact, a criminal history.
And he asked about the criminal history in a vague, non-specific way. He said, have you been involved in crime or anything up to no good? There was no level of specificity that would have given rise to the assumption, based on the guy's answer, that he was trying to mislead the officer.
And even if it was a conviction, it also was entirely unrelated to what the officer stopped the driver for in this case, or what was ultimately found. So that really seems to be a bit of a stretch.
Okay, let's move now to the D.C. Circuit. Evan?
So this case is called Waterkeeper Alliance v. Environmental Protection Agency, and there's really no other, simple way to say this. This case is about a lot of animal waste. Animals, as anybody who owns pets or has ever lived on a farm know, emit a lot of waste. In particular, they emit hydrogen sulfide and also ammonia, which is regulated under a couple of different federal statutes that impose reporting requirements on facilities, properties that on which activities are conducted that produce more than 100 pounds of these hazardous chemicals per day. This case involves a exemption that the EPA made for farms that are under a certain size concerning these reporting requirements. Basically said that because the EPA would not respond to the reports or take any actions to abate these emissions on these farms, therefore, we're not going to follow through with that. And the question is whether they could do so and still remain compliant with the law.
And what did the D.C. Circuit hold?
So the D.C. Circuit held to vacate the rule and and so the plaintiffs won on that. They found that on the first holding was that the EPA had failed to show any statutory ambiguity on the issue in question, which is whether the EPA had power to exempt reporting of the air emissions from animal waste. And that's required at the first stage of Chevron. So you don't even get to the second stage of Chevron in this case. The second stage being the usual fight about the reasonableness.
Well, the majority kind of conflates the two stages, which actually feeds into the dissent that we'll talk about in a couple of minutes. But basically, that's right.
The concurrence.
The concurrence that we'll talk about in a minute. But yeah, basically that's right. The EPA said, look, within the statute, you have a couple of authorizations that allow the agency to provide exemptions. This is an exemption, therefore we should be allowed to make it. But as the court points out, the fact that the statute authorizes exemptions under a couple of specified circumstances and also has an otherwise unyielding ironclad requirements that if you go above this amount of emissions per day, you need to make a report of that, doesn't give rise to a statutory ambiguity or uncertainty that would allow the agency to, on an ad hoc basis, decide that it's not going to require emitters to report those emissions because it would be difficult or impractical to the agency.
Now, the concurrence says this is an example of a renaissance against judicial abdication. What is meant by that?
I think what that's getting at is really what we've already touched on, that if there is no statutory ambiguity, then it's the court's role to say that and to have the agency actually apply the statute. That there's no room for agency interpretation. And certainly not lawmaking, when there's no ambiguity in the statute. Congress has already ruled on this question by saying there's no delegated authority to the EPA to issue exemptions. So that really is the end of the case.
So I actually have a somewhat different interpretation of what's going on in the concurrence. The majority doesn't cleanly distinguish between black letter Chevron Step 1 and Chevron Step 2. It doesn't say, we've made a determination, this statute is ambiguous, therefore let's proceed to determine whether the agency's interpretation of this ambiguous statute is reasonable. It kind of runs the ambiguity and reasonableness inquiries together. And what the concurrence does is basically throw up a warning flag about conflating Chevron Step 1 and Step 2. Janice Rogers Brown is, very serious about textualist statutory interpretation, and her basic thesis is, with respect to the two steps of Chevron, that if you conflate the two steps, and if you just look to the reasonableness of the agency's statutory interpretation without making an initial effort to fix the meaning of the statute and determine whether it's ambiguous or not, you will get a lot of deference, and you will allow agencies to escape the statutory bounds that give them authority. And despite the fact that scholars have, over the course of, it's probably over a decade now, argued that the two steps of Chevron should be consolidated into a one-step worth of reasonableness inquiry, it's very helpful for courts that are reviewing agency interpretations of statutes to make an initial effort at Step 1 to try to independently fix the meaning of the statute before going any further. And she's concerned that the majority is not actually doing that they're bringing this two steps together.
Another interesting aspect of this case is that environmentalists and progressives get a win. And it's, typically progressives are in favor of Chevron-style deference, are they not? And in this case, it comes out in their favor.
Right, and that's the interesting legacy of Chevron, is that it was initially opposed by environmentalists because it would allow agencies that were bent on deregulating to have an easier time deregulating on the basis of political considerations instead of the mandates of the law and the requirements that really underlie the fundamental function of the APA, which is to ensure that a reasoned, non-arbitrary decision is made concerning regulation. So in this case, you have a result that is the agency is not allowed to exempt these entities from regulation, but you have genuine judicial engagements in terms of you have a careful look at the statute, you have a careful look at the record, and you have a requirement that the agency offer an honest, reasoned, statutorily justifiable position for its actions, which is what we ask.
Right.
Just in defense of the circuit, of the D.C. Circuit's main opinion, it didn't actually get to the reasonableness stage. The concurrence was making that point that you've got to separate out the two Chevron prongs, but the main opinion didn't actually get to the point of conflating. There was a risk there, but they managed to stay away from that.
Yeah, I'm not sure about that. I think that Janice Rogers Brown is actually right about the fact that they kind of dance around the two steps. They say, of course, even if it's ambiguous, we still need to make sure that it's reasonable. But I think what she was set off was the fact that those two steps weren't cleanly distinguished. I mean, I hold no brief in this. And in fact, to the extent that I have a considered position, it's that the first step of the two-step inquiry is largely unnecessary. But I do think that there's a little intramural dispute going on as to concerning whether the panel majority is moving away from a two-step approach. If they are, it's going to create a lot of problems for their case law because the D.C. Circuit has actually created this sub-Chevron doctrine whereby if an agency hasn't made a determination that a statute is ambiguous, the D.C. Circuit will remand the regulation back to the agency and basically say, make a determination and then go forward. And you can't do that if you collapse steps 1 and 2.
Okay, let's move on to the next case, which comes out of the 10th Circuit and involves prairie dogs. Evan?
And so this case comes out of the 10th Circuit. It's called People for the Ethical Treatment of Property Owners versus United States Fish and Wildlife Service. And it involves a burrowing rodent called the Utah prairie dog, which is resident only in Utah, and which, despite being very cute, tends to do a great deal of damage to both private and public lands. It is protected pursuant to the Endangered Species Act, has been protected since, I think, about 1984, designated as threatened, which means that there's a foreseeable chance that it could go extinct in the future if efforts aren't made to protect it. And the Fish and Wildlife Service recently issued a rule that basically says that you can't, if you are a private landowner, take a prairie dog unless you get a permit for it. And the question is whether the Endangered Species Act, to the extent that it authorizes, or rather, this regulation issued under the authority of the Endangered Species Act is within Congress's constitutional power.
When you say take, that covers everything between killing it or just humanely capturing it and removing it to somewhere.
Anything that you do that disturbs the Utah prairie dog's habitats falls within the scope of the definition that's been set for taking a prairie dog. So there's very little that you can do with respect to the prairie dog without taking it.
So if a prairie dog shows up on your property, you can't build on it. If it destroys your garden, that's too bad.
That's right.
There's a bunch of other examples from the opinion. Apparently, it was burrowing under an airport runway and causing structural damage.
Yeah. I mean, you
have to get a federal permit to deal with that.
There are exceptional cases in which the animal has done a great deal of damage that threatens human life, and for that you don't need a permit. But the basic premise of this is that Fish and Wildlife can regulate the taking of prairie dogs on not only public lands but also private lands. And a district court decision from 2014 kind of sent shockwaves through the world when a judge held that Congress's Commerce Clause powers, which have been determined to be quite vast over the scope of the last few decades, doesn't reach to the point where Fish and Wildlife can regulate the taking of an entirely intrastate species that has no discernible effect on any kind of commerce or markets whatsoever.
So the Commerce Clause, Ricard, allows the federal government to regulate commerce between the states, but here we have a situation where there's not really commerce and it's not between the states.
That's right. That's certainly the facts of the case, and so the court makes the issue one of whether Congress has a rational basis, and we can talk about that a bit later, to find that the intrastate activity of the take of prairie dogs is an essential part of the Endangered Species Act. So we're not looking. The court says don't look at the take in aggregate. Look at the whole act, the statute, the Endangered Species Act.
And don't look just at the prairie dog. Look at all the other animals that are intrastates, that are threatened, that the ESA is designed to protect. Aggregate all of their activities and imagine the effect that might have on interstate commerce, and then conclude that ultimately, as the court does conclude, that Congress does have this particular authority.
Yeah, I agree with that. The 2 points I'd make on that. One, the court isn't aggregating the prairie dog take. It's going, as we just pointed out, to well beyond that, and then saying, well, is that an essential part of the act? Well, sure it is, because by the time you've aggregated to that extent, you're covering most of what the act does. So we're not looking at this particular regulation and what's happening here, even on just a limited question of whether it's an essential part of the act overall. And then the second part of that is that the court says, in a footnote, but nonetheless the court says it, that there's an irrebuttable presumption that if the regulatory scheme, the animal conservation here, targets economic activity or commercial activity, that means that it's then interstate commerce. Now, that's exactly the question we're here they're there to decide. So that irrebuttable presumption pretty much, and I'm sure we can talk about the rational basis test in a minute, but that really ends the case, because if you've got an irrebuttable presumption on that issue, well, there's no guessing. I mean, we know what the answer is going to be.
And the court uses this locution throughout, stating that there's no question that the ESA substantially affects intrastate commerce. That's not the inquiry that the court is supposed to be making. The question is not whether, if you pass a massive statute that authorizes a bunch of subordinate regulations that prevent people from doing things, you will impact commerce. It's a question of whether this particular activity that the government is asserting authority to control and to regulate falls within the scope either of commerce or something that is incidental to the commercial activity or a market for a particular commodity. And neither of those things is the case with the prairie dog. I mean, the courts suggest that if we go, animal by animal, and we question whether the taking of this animal will have a substantial impact on interstate commerce, we'll end up invalidating the entire Endangered Species Act. It's just simply bogus. I mean, take something like the bald eagle, for instance. There is a national market in commodities related to the bald eagle. People hunt bald eagles, they kill bald eagles, they exchange the remains of bald eagles for money. It's valuable to people, and that's why the ESA authorizes and properly authorizes the government to regulate the taking of that animal. No such thing is true of the prairie dog.
The other point on this is that if you take the Commerce Clause jurisprudence in the past looked at the actual interstate activity and said, okay, that's at the heart of the Commerce Clause. Now, what additional incidental and necessary regulations can Congress add to that to bring local activities or effects within the Commerce Clause? The exact opposite is being done here. The court's aggregating all the intrastate species, like the prairie dog, and saying, well, that adds up to 68%, so that's obviously a huge percentage of the act. How about looking at it the other way? Look at what the interstate species are, and then add to that what other local species maybe have to be preserved or conserved in order to maintain the regulatory scheme and add to that. That would be a more principled way, I think, I'd suggest, of going about this analysis. Now, you may get to a close number, but maybe you won't, and that's exactly the point. We don't know here because the court doesn't go through that analysis, doesn't raise any of the evidence if there was evidence in the record about it, and you'd imagine there would be. So really, it seems like we're turning this the whole Commerce Clause jurisprudence and analysis on its head.
Yeah, I mean, it's easy to make fun of this court's Commerce Clause jurisprudence for authorizing a hell of a lot of federal activity that the framers not only didn't envision, but probably would have found quite alarming. But there are limiting principles, and it is difficult to find such a limiting principle in this opinion. It seems to stand for the proposition that so long as you have a big statute that enacts a comprehensive regulatory scheme that affects commerce in some way, everything that falls within the scope of that statute, no matter how unrelated to commercial activity in and of itself, can effectively claim the Commerce Clause imprimatur of the entire statute itself. So it's very difficult to imagine a species that couldn't be regulated under this theory of the Commerce Clause, even if there are subordinate regulations that do constrain what agencies can do under it.
Okay, let's move on to the final case, which comes out of the Ninth Circuit. Ricard?
This case is Real versus City of Long Beach, a Ninth Circuit case where the plaintiff is a tattoo artist who wanted to open a tattoo shop in Long Beach, California. He can't do that or couldn't do that because of the city's restrictive zoning ordinance. So the ordinance prohibits tattoo shops from most of Long Beach. They can't open within 1,000 feet of any other tattoo shop, any bar, any fortune-telling establishment, any arcade, any adult entertainment. And the court tells us that that's a lot of the city. The plaintiff also can't open his tattoo shop because the city requires a conditional use permit to be obtained. And in order to obtain that permit, city officials have to conclude that the proposed use, the tattoo shop, will not be detrimental to public health, safety, or general welfare, environmental quality, or quality of life. If you can think of a description more vague and broad than that would be... that would be something. So anyway, the plaintiff challenges both those requirements, the zoning ordinance and the permit requirement under the First Amendment as unlawful prior restraints on constitutionally protected expression, which is what the Supreme Court has previously held tattooing to be. And in fact, the business of tattooing, not just the tattoo itself.
And so the district court holds that, sorry, you didn't apply for the permit, so you don't
that you knew that you weren't going to get, and you didn't spend a ton of money on the off chance that your permit would be approved before you can bring a constitutional claim that is acknowledged to be a constitutional claim because the Ninth Circuit has previously held that tattooing is a protected and First Amendment activity. Yeah, it's totally ridiculous. The district court botches the standing analysis, and the Ninth Circuit properly explains how they botched the standing analysis. They also botched the prior restraint analysis. I mean, a prior restraint is basically a requirement that you get permission from the government before you can speak about a particular thing. It's the most highly constitutionally disfavored form of restriction on speech because there's an inherent chilling effect that involves going before the government and asking the permission to engage in a particular activity. And the district court says, well, this isn't really a prior restraint per se because in some cases the officials have said yes. That's completely wrong. The prior restraint comes in the form of the initial requirements, and the evil of the prior restraint lies in the discretion to choose to say you can exercise this right, but you can't, not in the fact that it's either a categorical bar or it's not.
On the other part of the standing issue was the plaintiff's facial challenge to the regulation, the zoning ordinances under the First Amendment, and the district court manages to get this wrong too. And this again seems relatively basic First Amendment jurisprudence that you don't have to show evidence of the targeted regulations' effects on third parties when you're challenging it facially. I mean, the First Amendment begins with Congress shall pass no law which has been applied to the states. So there really is no need for that. And the Ninth Circuit, again, gets it right and reverses the district court on that.
Just to build on that, especially in the context where the particular objection that the plaintiff is making in this case is that you have a permitting process that effectively gives officials unguided discretion. It would be impossible to resolve as-applied challenges under those circumstances because the criteria that officials are using to decide you and not you are so subjective and so fact-intensive. So it's embarrassingly bad performance by the district courts, very engaged opinion by the Ninth Circuit, basically affirming well-settled standing and First Amendment principles in the face of a district court that abdicated its responsibility to give effect to both.
One other quick point on the actual unlawful prior restraint claim. The Ninth Circuit also points out, where the district court apparently didn't pick this up, that the zoning ordinance itself doesn't have a time limit by which a decision has to be issued. First Amendment jurisprudence, because of the chilling effect that we talked about a minute ago, requires that deadline to be within a provision so that there's a limit on whatever speech, constitutionally protected speech, is being restricted by the targeted provision, at least until a decision is made that can then be challenged.
Bottom line is this case should go forward. It will go forward, and the guy should win. This is a viable First Amendment claim. It is a prior restraint on speech, and I doubt that the city can justify it.
Okay, that concludes the show. Thanks for listening. Until next time, this is John Ross from the Institute for Justice, prompting you to get engaged.